Hi, I'm Scott Johnson, General Counsel at Louisiana Realtors, and this is a video recap of the topics covered during last week in Risk Management Month. We started out on Monday looking at what risk management is, and we identified several sources of risk. At the end of the day, risk management is just a way of avoiding bad consequences by planning ahead. So take time to think about the various sources of risk facing real estate agents. One area is to comply with state law, which includes license law, the law of agency, and various other Louisiana Real Estate Commission rules and regulations. There's also federal law to consider, including RESPA, fair housing laws, and antitrust laws. The Code of Ethics binds all realtors, and the law of negligence imposes on realtors the same duty that all citizens have, the duty to avoid causing harm to others. So with all these potential pitfalls facing realtors, what is one to do? The best practice is to educate yourself. Feel free to use the resources at larealtors.org or take one of the many classes offered by Louisiana Realtors. Your local board and NAR offer a number of resources to help you as well. Another thing to do is to review your insurance policies. Make sure that you don't just have the minimum required state E&O policy, but review your homeowner's policy and your automobile policy, as these can protect you when you face a lawsuit. Next, develop good practices, including written policies and procedures to make sure you and others in your office don't overlook key obligations in a transaction. Be familiar with mandatory forms, including the agency disclosure form and the statewide purchase agreement, so that you're familiar with their contents and can use them with expertise. Finally, rely on other experts. Just as home buyers and sellers rely on your professional expertise, you should rely on lawyers and accountants to answer the key legal and accounting questions that you have in your practice. Finally, stay tuned for the rest of the updates during Risk Management Month, where you'll find numerous tips that will help you avoid risk in your practice. On Tuesday, we covered the law of agency changes, which go into effect August 15th, having been passed by the Louisiana legislature and signed into law by the governor. The biggest change involves when you give a consumer or a client the agency disclosure form. Whereas in the past you were required to deliver that form to anybody on first contact, the law has changed and now you provide it at first substantive contact. That means as soon as a customer or client gets to this point of a conversation where they're likely to give you confidential information, that's when you should give them the agency disclosure form. Another change in the law involves designated agency. Whereas in the past the law required a broker to personally designate which agent would represent a client within his or her office, now the agent working with that client is presumed to be the designated agent without requirement of any action by the broker. Finally, based on these changes, you can expect the Louisiana Real Estate Commission to come up with a new form which will go into effect for use January 1st of 2011. So stay tuned for that new form. On Wednesday, we covered the difference in two legal terms, breach and default of contract. A breach is any failure to perform an obligation that one undertakes in a contract, whereas putting someone into default is a step in the process necessary to occasionally recover damages or seek other relief under the contract. A tip for realtors is to use plain English and leave the legalese to the lawyers. If there's a problem with one side's performance under the contract, help your client communicate with the other side to clarify what the obligations are. If that discussion breaks down, encourage your client to seek legal advice. On Thursday, we talked about escrow deposits and specifically looked at which broker is responsible for holding that deposit pending a sale. It turns out the answer is either one. While customs may exist from region to region as to which broker holds that money, at the end of the day, the customers and clients who are parties to the contract make that final decision. The duties to the broker are the same, so the choice really shouldn't matter. At the end of the day, the broker, whether they represent the seller or the buyer, has the obligation not to commingle the funds. They've got to use their escrow account. They shouldn't disperse the funds without permission of both parties. And in the case of a dispute, the broker is obligated to notify both parties of that dispute. If there's a dispute that can't be resolved, the broker has two primary options. The first is to file a concursus proceeding with the court, which will leave the court to decide between the parties who is entitled to that deposit. The broker can also decide to disperse the funds in accordance with their own reasonable interpretation of the contract, but only after giving both sides 10 days notice of their intent. On Friday, we covered the New Home Warranty Act. That act provides 3 coverage periods warranting all new residential construction. For the first year, the home is warranted to be free from all defects. For 2 years, the major systems, such as heating, plumbing, and air conditioning, are warranted to be free from defects. And then for 5 years, the home is warranted to be free from major structural defects. The question arises, when do these periods of time start? The law provides that it starts on the earlier of one of 2 dates, either the date of occupancy in the home or the date title is transferred, whichever comes first. So consider the situation of a home constructed and then occupied by a builder for 1 year. In that instance, the home warranty would commence from the date the builder moved in, and a new owner would inherit only the 2- and 5-year coverage periods. The other thing to be considered by owners of new homes is the time limit for notifying builders of defects. An owner must notify the builder in writing within 30 days of the expiration of the relevant period. Thus, with an air conditioning problem, the new homeowner must notify the builder of the defect in writing within 30 days of the 2-year anniversary of their purchase or occupation of the home. Thanks for watching, and stay tuned for more helpful information during Risk Management Month.